Hello and welcome to today's episode of Coffee Breaks Connecting Minds. My name is Edvins Draba and I'm a senior associate with Sorrainen law firm in Latvia. And within INSOL Europe, I serve as a country coordinator for Latvia. And our today's guest is Ieva Broka, who is a member of the board of the Latvian Association of Certified Insolvency Administrators. So, hello, Ieva.
Yes, hello. Good to see you.
So, before we move on, could you please briefly introduce the association you're representing and outline its role in the insolvency and restructuring field?
Yeah. So the Association of Latvian Certified Insolvency Administrator, actually we basically use a short version, is Association of Administrators, as we're actually not anymore certified, we're just administrators who are appointed by our controlling institution as well as from court, so we are administrators. So it's independent professional association of all insolvency administrator, and according to insolvency law, it implements the functions and of a professional organization of insolvency process administrators. So we unite all administrators in Latvia. The objectives of our association is to ensure the organizational unity of administrators, to represent, defend, and improve the professional interests of administrators, as well as to perform the tasks assigned to us in order to promote high-quality legal protection in insolvency proceedings. Currently, we are 175 administrators as members of our association. It's also very important to emphasize that apart from being an independent professional organization of insolvency administrator, our rights to unite all insolvency administrators are stated in insolvency law. It's not just by our initiative. We have written our rights in insolvency law. And as of January 1st, 2020, the legislator has assigned also to our association rights as a supervisory institution or organization and control authority in relations to the subject of law and prevention of money laundering and terrorism and proliferation financing. So it's a new role for us, entrusted by state. And we actually congratulate our legislator of comprehension of administrators' role in Latvia's economy, as well as support towards future development of our administrators' profession itself, becoming a complete self-governed independent legal profession. That's our aim, and that's what we see as our future way. Similarly, like the other legal professions in Latvia, like advocates, bailiffs, notaries. So, yeah.
Okay. We're in the middle of the COVID-19 pandemic. The last year was tough overall, but we did not experience a spike in the amount of insolvency proceedings. So could you please provide a general outlook on the current situation concerning insolvency and restructuring proceedings in Latvia in the context of COVID-19 pandemic, and how is the current situation affecting the work of insolvency administrators?
Yeah, well, it's been a very, very challenging and very interesting, if I may say so, year with new unexpected turbulences in our economy. And obviously it has affected our work as well. And but if we look at well, these will be some predictions or some speculations of how we see that. The insolvency proceedings, we have to look at the last year in light of a lot of legislator initiatives and new laws in place, especially regards insolvency proceedings, which so in Latvia really pandemic crisis started in mid-March, and already in mid-June or 10th of June, a legislator imposed a moratorium for creditors to apply for debtors insolvency until 1st of September. And now we have the same law in place since January now until March 1st. So, but coming back to the last year, so it was kind of expected that some, like 1st of September, will start a flood of insolvency applications from the creditors, but actually it didn't happen. So, and from September till the end of year, it was kind of a frozen situation, and insolvency proceedings didn't raise in numbers significantly, neither legal protection processes. So, and in this light, it is very difficult to predict what's going to be actually how the situation will be going in further. Although, as we have very strict rules in place regards different kinds of businesses, all like services and HoReCa, which is hotels, restaurants, etc. So it will affect, I think, dramatically. And some of the first hotel insolvency processes being in place. Well, like myself, last year I was administrator for one big hotel, and it was very, very hectic and very stressful work I had to do, which I would say that my fellow colleagues will be dealing with similar situations. But so as we're looking at the legal protection processes, so far in Latvia we haven't had a nice success stories in that field. So it's still a far and long way to go till the legal protection processes in Latvia gets its roots in really. It's a very our entrepreneur sees this as a very good vehicle to return to solvent situation. So it also need to be changed some cultural attitude from entrepreneurs, as well as from our tax office, which mainly is a main creditor in most of insolvency processes. So we need to connect these worlds, and also to see from the tax office as one of the main creditors, to see the support, not just a punishment attitude or closing down business attitude from them. So yeah, that's what else? And also the banks. Banks are very important in these processes. So yeah, and maybe I'll continue a bit further. So, but having said that, so I'm partly a supporter of this new initiative that comes along with the new restructurization directive.
Maybe let's talk about this point a bit further. Yeah.
Okay, all right.
Maybe could you give us your perspective on how do you evaluate this moratorium on filing for insolvency proceedings and measures imposed by the parliament and by the government in the insolvency field in general? Do they have the effect which they need to have, or would you do something different?
Well, in general, it seems to be appropriate decisions in a way for such crisis situation, because it's a very unique and new situation, and well, we have no experience to base on our decisions, and it had to be done so fast and rapid. Yeah. But actually it is clear now, with my experience and my fellow colleague experience, that the number of legislative decisions have been prematurely passed. and unreasoned. Some of them are unreasoned restrictions with regard to complete closure of various areas of businesses. And well, that's actually most of my personal opinion. I'm in full support of restrictions of maximum force to stop the virus, and all the precaution measures should be taken. But we also have to be very careful not to kill the businesses along the line. So and the consequences of these restrictions, they have not occurred yet, I think. We're still in the middle of a blizzard, I think, and but it will affect our lives with slight delay. Maybe I would say by the end of this year we will really face what the effect is to come. So and very crucial for Latvia. Well, in Europe's context, in the world's context, we are a very small country. So we have to be able to keep the small and medium-sized enterprises open, because this is the biggest taxpayers for Latvia. So and on the other hand, so we have to be very careful how our governments and states distribute the money, the help money from European Union, so it's used prudently, economically, and fairly.
Connecting to that point that you mentioned, that this year we will see maybe the true extent of the consequences of the pandemic. So do you expect the increase in the number of insolvencies or restructuring proceedings this year?
So my prediction is actually based on this also moratorium outcome or moratorium effect. So now we are sitting in this moratorium until March 1st, whereas creditors cannot apply for debtors' insolvency, and debtors itself, simply saying that they are not obliged to apply for insolvency in the manner it was before the pandemic. Yeah. So they have to be responsible. We're not refusing from the responsibility of the management of the board, but still it's not that strict requirement. So and if we look at the lucky scenario, which is prediction that in the springtime the virus will be more or less over, then I would say that in the first part of the year, the number of insolvency proceedings will increase, and then by the year it will go back to, let's say, normal or just a average numbers. But that my positive prediction that the virus will be finished by spring, it's quite a bit too optimistic, I would say. So basically, yeah, well, maybe there will be some flood of entrepreneurs trying to use legal protection processes, and these signs, as I've already noticed. But that depends on the full support from tax office, because this is the first creditor that appears in nowadays, as well as the banks which hold the mortgages over the valuable assets, whether they will want to close it and sell the assets, or just keep it viable until this disaster is over. So, and these initiatives should be coordinated, because we have to work in the same direction if we're talking about legal protection plan, actual living opportunities. So
okay. Understood. So maybe let's talk a bit about the Directive on Restructuring and Insolvency, which you mentioned already.
Yeah,
so
and
there are.
Sorry, Edvins. I was just one thing I wanted to. I've just made some notes. I wanted to emphasize: if you have to look at the Latvia situation, even if the numbers either raise or drop, depending on these, as I said, speculation. That if you look at our association, that at the moment, we're not working in a full capacity. So the number of administrators we have now, So we are actually facing some really slowdown in our activities. So in case of there's an increase in number of insolvency processes, we are very ready to take whatever is on the board. So so we're not working currently on a full capacity. If it's very mere sort of describing of some of administrators who are not having a legal practice along with administrators' practice actually are facing some financial difficulties due to the COVID impact.
Okay, understood. So let's maybe turn to this directive on restructuring and insolvency. Right. And we know there are draft amendments to insolvency law under consideration by the government aimed at implementing this directive, including its provisions on the position of the professional in the field of restructuring. And currently we know that in Latvia there's almost totally free market of professionals who can supervise restructuring proceedings. Now, these amendments propose to narrow the range of persons who can supervise restructuring proceedings in Latvia to several categories. And insolvency administrators is one of those categories. And in addition, the amendments provide for the supervision of the restructuring proceedings during the period when the debtor is drafting a restructuring plan and negotiating it with the creditors. Because currently the supervisor is only appointed when prior to the review of the restructuring plan in court, and usually the supervisor does not have a role during the negotiation phase of the plan. So where do insolvency administrators fit here? How do you see their role, and what is your take on the amendments, maybe on the directive in general?
Okay, yeah. So generally speaking, all these new amendments are important novelty in our field, and even our legislators has to work very fast due to the deadlines for implementation. But still, I would strongly suggest, and I'm also saying out loud in every working group I sit, discussing about this directive, that to reassess all pros and cons before inventing any new regulations, and especially as regards this new regulations for the supervising person. And actually, we do not support inventing a new profession as like a professional in the field of restructuring, because we have already very good professionals who would fit in this role very, very nicely. I agree totally that the range or the field of who can be a supervising person in this process should be narrowed, as at the current regulation is actually it was very I'd say very open and too open for interpretation. So, and the history has proven that this very democratic or very free attitude has not given any good results. So it hasn't improved situation with legal protection processes. So generally this directive is very positive initiative and positive sign for Latvia's legislators to have a better regulation of this process. That's general. And obviously, representing our association, we stand ready to fill this role, definitely. And actually, looking at the current regulation, I think we are in a very in the right way, choosing administrators as one of the potential restructuring supervisors. But I would strongly suggest looking at these processes, that understanding that the supervisor of legal protection process needs to be more orientated on a business knowledge and economical issues. There's still lots of legal issues to be looked at, and the legal education or lawyer's education is crucial for this this person or supervisor. So I think that the main approach by choosing this person is that firstly it needs to be lawyer with additional knowledge in some economical and business issues. That would be approach we would choose if we wanted to for the supervisor. And we also think that supervisor, it is very crucial that actually supervisor is a part of drawing up a plan, because that the practicalities and the history proves that it is very important that supervisor is a part of preparation process. From one point of view, it is a professional, it is a lawyer, there is a legal criteria the plan needs to meet, and if the lawyer works hand in hand with economist or finance director or attracted or invited auditor, that the teamwork for the legal protection plan is the key to success. So and I congratulate the initiatives for these amendments, that the supervisor is could be a part in this draw-up process.
Okay. So maybe briefly, what are the biggest challenges and obstacles faced by insolvency administrators and restructuring supervisors, and what changes would you make to remove those obstacles and maybe improve the general efficiency of proceedings?
Yeah, so generally speaking, it would look like the administrators would need a better understanding in economics and in business itself. One is the numbers or bookkeeping records, but if you look at the criteria administrators meet already, we have to know very, very large amount of information about bookkeeping and economical issues of our debtors. So we have that knowledge more or less in a quite good level. So, but for some of our colleagues, that might be for lawyers with no additional economical education, that could be a challenge. That's one thing on one hand. So and the business knowledge itself. Some of our colleagues are more like theoretical lawyers or more like academic lawyers. So that the supervising person needs to have both academic knowledge in law, economy, as well as the practical business knowledge to understand what is in the plan and is it realistic. One of the real obstacles I see from also from my experience, that the supervisor has not the same active role as administrator has insolvency. So it is a really supervisor that some of information could be hidden from the supervisor, and that comes back to that business culture in Latvia, that not all the business people are very prudent. So quite frankly, it is, and that comes from our history, that comes from different backgrounds. But that's what we see, and if that changes, then one of the obstacles we have to remove, that there's a complete trust between the entrepreneur and the supervisory person. and also the fair fulfillment of obligations by administrator. So that's from both sides. And talking about the knowledge of business and economy studies, our association is a big part of it, as we run our training center. And in our training center, we provide different 2 or 3 per month, different types of lectures or opportunity to hear different experiences and different knowledges from the lawyers, tax people, police, business people. So, and we always try to follow the novelties and the current needs, what our members would need. Like the latest novelty is AML rules, so we organize a lot of lectures especially for that topic. So it is something new to learn, to get into life. So, and so we have to encourage our members to keep learning, as you have to learn all your life, and especially just to become better and on top of the profession. So.
Okay, so many thanks, Ieva, for your responses and for your time. Welcome. Have a nice afternoon.
Yeah, thank you, Edvins, and see you soon. Bye.
Bye.